Now I have Ms. Thomas going first, correct? Good morning.
Good morning, Your Honor.
Yeah, it was good morning.
My name is Cynthia Vincent Thomas, and I represent Dennis Reddy. This case is here on an application. This case is here on an application for further appellate review. There was a motion to dismiss, which was allowed in the trial court, and the appeals court reversed. There is one issue before the court this morning, which is determined under the principles of fundamental fairness. The defendant reasonably relied to his detriment on the Commonwealth's representation that he had the opportunity to dispose of his case in the district court, and that the district court case was to be held open so that he could go to the Superior Court and resolve his probation.
I have a question about the fact. Oh, well, I have a question about the facts that would help
Yes.
a lot, I think.
Okay.
You say that there's nothing in the record to indicate that the defendant lost the opportunity to resolve the case in district court. Now, in the on page 16 of the red brief, there's a footnote that says that the prosecutor announced his intent to indict on September 12th, 2005.
The defendant wasn't there.
Was his counsel there?
No, Your Honor. That actually is a factual error. The September 15th date was put in the defendant's motion to dismiss that he filed. It's a scrivener's error, because when you read the transcript, he clearly says, I don't know when they were going to indict. My understanding is they indicted on February 3rd, and the district attorney was there and said, yes, February 3rd. So why that September date came, he used it in his motion to dismiss other than as a scrivener's error, because it's clearly in light of the motion to dismiss transcript. There is a discussion as to when was there a decision to indict. He says, look, in fact, the judge says, well, and they indicted on September 15, correct? And the attorney says, the defense attorney says, no, Your Honor, we don't know when it happened. We do know it was presented to the grand jury in February, and the DA gets up and says February 3rd. And there's nothing about September. Now, I understand that the appeals court makes that a finding of fact, but that is not supported by the record, and it is an error.
So your contention is that essentially in withdrawing his plea, he did that in reliance on a promise by the government that he would eventually be able to resolve his complaint in the district court. So that's what he did. He withdrew his plea in reliance, in reasonable reliance on something the government promised him.
He withdrew his plea on reasonable reliance that the case would remain open for disposition, that the trial would be held in suspension. Well, the trial would not commence, but the time period would be extended for him to go to the Superior Court.
For 30 days, though. I mean, wasn't that very clear that it was only for 30 days?
Yes, it was clear. The judge said 30 days, but only for 30 days. I'd say no, not based on the record and not based on what happened after August 16th. Because what happens after August 16th...
Can you just finish the rest of the sentence?
I'm sorry.
You're saying reasonable reliance, that the case would remain open, that the trial would not commence...
That's right.
...until...
He resolved the matter in the Superior Court, so then he would
even if it took place, even if the, quote, resolution took place after 30 days?
Yes.
And who made that promise?
I think it's our position that it is implicit.
So
in
no
the record.
one said it in
That is correct.
in explicit language,
That
but you say that has to be kind of understood.
It is understood because of the acquiescence of the Commonwealth and because of their lack of action. This case was ready for trial in July. They never went forward on the trial. There was no reason to hold the case open. In the plea hearing, it's very clear. She says, is all the discovery completed? And they say yes. So the case was ready for trial. There's nothing to indicate in the record that they were anticipating an indictment in July. In fact, at the motion to dismiss...
But just clarify for me, at one point when they were discussing the plea, didn't the judge say, I'll take the plea now and postpone sentencing until after this other matter is resolved?
Your Honors, I would ask...
Didn't the judge say that?
I do not interpret it that way, and I'd ask the court to look at page 21 to 26 of the plea hearing. Because what it appears that she does is she's certainly frustrated. She understands the situation the defendant is trying to wrap up in all his cases, but she also needs to move the case along in the district court. And he wants her to withdraw the plea, reduce the bail so that he can go take care of his either parole or probation. At that point, it's not particularly clear. But she says, I hear everything you're saying, but I'm not going to reduce the bail. I could keep the plea, if somebody could give me some assurance that he's going to be sentenced, then I'll be willing to take the plea.
Where are you?
Excuse
What
me.
page?
On the bottom of page 21.
Of what?
At the end where the judge says, I hear everything, I hear what you're saying, and then she goes on to say, I'm willing to take the plea and come back and impose sentence on this matter after this matter is resolved, but I'm not going to reduce the bail. So he's going to go to his probation officer, he's going to do all these things, and she says, you need to get yourself haved in here.
So what was the next
But
event
then
that
what
was?
happens is then she takes a recess.
Yeah.
He never says, no, Your Honor, I don't want to take door number 2.
Well,
He-
is that where we read in the implicit?
Not yet.
Okay.
Because now there's a recess. So he hasn't rejected anything. She's just thinking about what she can do, but is frustrated that if she holds the case open for sentencing, she can't guarantee he's going to be back in time. And she doesn't want to hold it open for sentencing with the plea. So she says, okay, take a break. When they come back from the break, and that's the end of the transcript, she says, all right, this is what I'm going to do. You can withdraw the plea. I'm going to hold the case open for change of plea in 30 days. You go take care of business and you come back in 30 days. So when he leaves there, he believes he has the opportunity to go resolve his case in the Superior Court and then to come back and plead guilty in the District Court and then,
Within 30 days.
well, within 30 days. But the problem here, Your Honor, is what happens on the 30th day. The case is not, he doesn't come in. He has no information as to what's going on. The Commonwealth doesn't ever object in July.
30 days
Oh, excuse me.
expire.
And they don't say, okay, well, then we're ready for trial.
Let me ask you,
The 30 days expire,
right.
though. You agree with that?
Well, the 30 days do end. I don't think it doesn't end his reasonable interpretation.
So why doesn't he move to come back into court for a plea?
Well, Your Honor, there's nothing in the record with regard to that, except for the fact that he indicates that he's never brought in to court again. The status quo in his mind never changes. He's abandoned by his trial counsel. I mean, he's
who
never
was
brought
his-
in. Oh, I'm sorry.
when did you start representing him? Or is this just on the appeal?
On appeal, Your Honor.
So did he have, well, he obviously had a counsel in the Superior Court,
Yes.
right? So he had counsel for trial that was supposed to go forward on the July 28th, right?
It was on for pretrial conference that day, but yes. He was represented by counsel on July 28th.
Okay, and did that counsel, is there somewhere in the record that counsel withdrew?
The only evidence with information with regard to that attorney is the defendant's information in his affidavit
sick.
that he was sick and he never appeared in, well, he says he never appeared in court, but the defendant never appeared in court.
Well, except that on the docket sheet, doesn't say on at least one date, present, 12/20/05, present.
Right. The only thing on that, Your Honor, I would say again is this. The defendant, if the defendant had appeared on that date, if the defendant's in his affidavit, he didn't appear, the defendant said, the motion judge, found that credible. I just want to check one thing, Your Honor, I apologize. Then why wasn't the case, well, see, what it says there, Your Honor, is
What page are we,
present
what page are we
bail
on?
ni- oh, I'm
What
sorry.
page of the appendix, please?
This is the
26 of the
Commonwealth's
appendix.
appendix, page
26.
26, yes. And it says present mail bit, right? But does that mean present mail bit? Because when you look at page 25 of 26 of the plea hearing, at the end, the clerk says, okay, this matter will be put over to August 16th for change of plea, and MIT will issue present bail. So is it present bail, MIT, the MIT is for the present bail, or present bail, he's here? It's ambiguous, and the defendant's affidavit said he wasn't there. And if he was there, why wasn't there a trial date? Why wasn't there a trial date? They still hadn't chosen to indict until February. If this case was not open for him to resolve his case, then why is the Commonwealth continually agreeing to continue pre-trial conference hearings?
Well, I take it there's no question that the defendant could have chosen to go to trial here. He's withdrawn his plea. He wasn't bound in any respect to plead guilty, for sure.
But he was given an opportunity, Your Honor, and he
Yeah.
took the opportunity. He chose to take
An
the
op- But
opportunity.
an open-ended opportunity? When
It
you, when
turned-
you get around to it, we'll let you come in and plead to this deal?
It turned into an open-ended opportunity based on the principles of fundamental fairness.
The Commonwealth can't
Because
withdraw it
he-
at some point when
Well-
it turns into an open-ended opportunity by simply proceeding otherwise?
No. They could have withdrawn. They could have argued he breached. We want to withdraw, but the
Well,
problem...
this isn't a contract action.
But, Your Honor, if they wanted to withdraw, they'd have to show by preponderance of the evidence that the defendant breached. They never raised it. They never raised that issue. They never said, we're tired of waiting for him.
Are you suggesting we should do a contract analysis to this?
No, Your Honor, but I'm saying if we're going to say that the Commonwealth could withdraw, then there has to be, they simply cannot withdraw. They just cannot withdraw unless
But
there's
the
a reason for it.
Commonwealth has made, you would agree, the Commonwealth made no affirmative commitment other than they agreed to a plea on July 28th with, I take it, unagreed recommendations. And they certainly didn't object when the judge says, okay, I'm going to let you withdraw your plea and continue it for a change of plea on August 16th. That's as much as we know the Commonwealth agreeing to, isn't it?
At that point.
Well,
The problem is the case doesn't end, Your Honor. If the case ended on on July 28th, August 16th, if they, at that point, moved for trial and then indicted, well, then we wouldn't be here today. It's the circumstances that happen after
But
August 16th.
how does the docket sheet in the district court, it never says anything about defendant not being present on these later dates.
but it doesn't say a word.
Doesn't say anything.
No, I know, so,
Oh, on the later dates, I'm sorry, Your Honor, which dates?
no, on the later dates,
the later.
say 9/12/05, 8/16, 11/4/05, how do we know he wasn't present?
Well, the defendant's affidavit indicates that he wasn't present.
No
And
one
again,
has
if
any
he was
counteract
present, then why
I
isn't the
know he
case
says he
on-
wasn't, but how come the docket sheet doesn't say defendant not present?
The docket sheet doesn't say the defendant is present either. But if he was
Well, but
present-
normally the defendant, what I'm saying is normally he is present, so,
Well, not when you're in custody in Plymouth County and you're trying to get yourself into Suffolk County because you're going to try to resolve your case in a superior court in another
but
county.
this is a
may
Plymouth
not
County, but
necessarily mean-
this is a Plymouth County docket sheet.
Right. No, this is for the case in Plymouth County. I would
Right,
agree.
and so we don't have any indication that he's having a problem getting himself into Plymouth.
There's nothing to indicate anything that the MIT, there's evidence there to indicate that the MIT issued, not that the MIT was served, and not that the body was brought in, and not that any hearing was held, any objection by the Commonwealth for further pretrial conference, any request by the Commonwealth for a trial, which I think is the key, because they had no intention to indict, according to them, till at least February 3rd. The case was ready for trial. If they just said, hey, no, we're tired of waiting for you, your opportunity ended on August 26th, let's put this case down for trial, then why is there not an objection to the pretrial conference hearing? Why is there not, did they not move for trial? The district attorney's office is in the courtroom every single day. Maybe it's not the same DA, but there's somebody there from the district attorney's office, and what were they doing? Obviously not objecting and not moving for trial, letting the status quo continue beyond the August 16th date. And the defendant having no information, how would he believe that anything had changed, the status quo has changed? He was getting yelled at, look, it's going to be a trial. He would have thought, I'd be moved in for
Does
trial.
it boil down to, we analyze what the judge said about, I'll give you until August 16th, and if we think that left the door open, then we say there was some implicit fundamental fairness
Yes.
issue that tilts for the defendant, or if we think that was an offer that ended after 30 days, then you lose? Would it boil
Yes.
down to that?
Yeah, I think if you find that he reasonably believed that it ended, that there's no reasonable reason for him to
Don't we
believe
have to
otherwise.
be objective and look at the judge's word?
Correct. No, I agree with you, Ron. If you find that he reasonably, all that the defendant could have reasonably believed was that he had 30 days, then there's a problem. But I still say, because we're looking at it on the issues of fundamental fairness and due process, you need to look beyond, because the case did not end on August 16th. There's so much more that went on with no explanation.
So are you suggesting if they indicted him in September, that would have been okay?
No.
Okay.
What if they had telephoned up defense counsel and said, listen, we're tired of waiting. If he doesn't come in and plead guilty by this date, we're going to proceed with an indictment. Any problem if they had done that?
No, that would raise a different issue between the defendant and his attorney, perhaps. But at least there was the Commonwealth could have some affirmative showing that well, actually, can I take that back, Your Honor? There would be some affirmative showing that the Commonwealth at least withdrew. But before they could withdraw, I would say that they would have to show that the defendant somehow breached, that he didn't
Well,
do
but I
what he
mean,
was
but
supposed to
that's
do.
what I'm trying to figure out what your implicit promise is. I thought, and I guess you differ, I thought that what you were arguing is that the implicit promise here is that the defendant would not be indicted as provided that he promptly pled guilty after being sentenced on the parole violation, that that's how it was left
Right.
at the conclusion of this hearing. But then he didn't
Correct.
promptly proceed to get, well, he didn't promptly proceed to resolve his parole case.
Well, we don't know whether or not he promptly proceeded, because
Well, it's-
that was never an issue
Okay,
raised.
but it certainly was not resolved as of February 3rd. And we don't know
Well-
what, if anything, he did.
Your Honor, I would simply say that would not be accurate. It was, well, it's not part of the record, it wasn't raised as an issue, but that would be a wrong factual assumption to make.
Right, but I thought the parole violation occurred after February 3rd. I mean, after Judge Locke's decision, then apparently, I gather, he was sentenced on the parole
Oh,
violation.
I'm sorry, Your Honor, the parole violation, I thought we were talking about the probation surrender.
No, I gather it was I gather what he wanted here was he wanted to resolve the parole violation, knowing he'd get some time, and then he wanted to make this case concurrent with that.
Right. There's some confusion there with the parole and the probation, but the issue was getting himself from Hingham District Court to Suffolk Superior Court, and Suffolk Superior Court cannot violate you on your parole. They can only do the probation surrender. So there's this back and forth of parole, probation, but the issue of going to Boston and was to take care of his probation surrender. He was talking about calling his probation officer and getting himself in there to get a sentence to run concurrent after they go through this process.
So he was trying to get a concurrent for a probation violation, not a parole violation.
Well, I think he would have liked to gotten everything wrapped up, and they're using the terminology interrelatedly, but the bottom line is, when he talks, as opposed to his lawyer, he says, I want to go, I've called my probation officer. I'm going to try to get me to get into Boston. I'm going to go in there, I'm going to take care of my probation matter, and then I'm going to come back and be able to have concurrent time. I mean, the court knows that the Superior Court cannot violate him on his parole, nor can his probation officer. Everything the defendant is talking about is the probation matter. Granted, the parole issue was after he did his probation surrender and did his time. He then was released on bail on this case and then went back to the prison before the parole board and agreed to violation there.
And all this time, he is still in custody on this case, which means he's doing essentially on and after time to any of the parole or probation violations.
That's, and that goes into the reasonable
But I'm
reliance
sorry,
that-
I don't follow you, because on page 21 of the plea hearing, it says, downstairs, he's saying, defendant, downstairs I have a parole
right,
detainer
it
down
does.
there. Indicates 19 to 20 years at Cedar Junction. And the purpose here of I'm asking, requesting that the bail be taken 19 to 20 and then come back here next week and be sentenced. I thought that he was wanting to get his parole detainer taken care of and then get the sentence here.
So, but then the very next page, he says, right here, I'm on my probation officer from Suffolk. Yeah, he has me in violation now. I know, being in default. I know, I understand. You need to get yourself haved in there. Well, you're not going to get yourself haved into the prison for parole. Parole is his concern, probation his concern. But they're talking about calling the probation officer to get to the Superior Court. That's what the case was continued for. There's clearly two issues he had going there.
But
How
when
can
he
anybody
wanted-
possibly understand what was going on here? I mean,
Well, the
the
inaudible's
judge
a
gave him
problem.
30 days to wrap up his business, and the 30 days passed. Isn't that the end of the story?
No, Your Honor. It isn't the end of the story, because how can we explain on the doctrine of fundamental fairness what happened after August 16th? He's abandoned by his attorney. He's incarcerated. He's going through 2 different courthouses, 2 different counties. This happened in June of '05 when he was arraigned. It's almost June of '10, and for almost 5 years he's either been on bail in this case, in custody in the House of Correction on the probation surrender, in the state prison on the parole violation, and in September of '08 he's been on supervised probation on this case under the custody and the supervision of the probation department. And even though they ultimately indicted him for 20-year minimum mandatory, they only offered him a 5-year sentence in January of '07. So the Commonwealth has certainly got their pound of flesh in this case. The court can certainly take a narrow view and ended it August, but I'd
Thank
ask
you,
the court
Ms.
to look
Thomas.
further. Thank you, Your Honor, I'm sorry.
Mr. Thompson, good morning.
Good morning, Your Honor. It's Robert Thompson on behalf of the Commonwealth. Your Honor, there's no question the Commonwealth is obliged to comply with any inducements or promises it makes on which the defendant reasonably relies, but it requires, in order to have such a thing, it requires some kind of affirmative action by the Commonwealth that would give rise to the defendant's reasonable reliance.
Mr. Thompson, as a matter of curiosity, how could this defendant have been allowed to sit in jail for so many months without being brought back into court?
Your Honor, the record is before the court. I can't speak to why he was not there. I know he was being held not just on this, but also on the parole violation, also on the probation
But doesn't
violation.
the Commonwealth have some responsibility to get him back into court? He can't just be allowed, this case can't be allowed to fall through the cracks.
Well, Your Honor, I don't know why the proceedings didn't take place. I don't know why they didn't happen on those days. I don't
Do you know who
if
the
it's
prosecutor
because
was?
of the defense attorney was not present or asked for a continuance or any of that. There was no objection to any delay by the defendant, no objection. All that, Your Honor, I suggest is immaterial, because here, from the very beginning, there has never been any kind of promise or inducement by the Commonwealth in any way whatsoever.
But my question really is, and I understand your view, that, but my question specifically was, as a matter of curiosity, how could this how can we tolerate this?
Your Honor, delays happen, unfortunately, in the district court all the time, and ideally, they wouldn't happen. Certainly, they would never happen. The delay is generally not to the benefit of the Commonwealth. It's not something the Commonwealth seeks.
But doesn't the Commonwealth have some responsibility here? I understand
No,
about the
Your Honor,
promise
in fact,
part. No,
we do
wait,
not.
hold it. You don't know what I'm going to ask. I mean, not on the promise question, on this issue that Justice Spina's raising, where there's a list, the case just keeps getting put over and put over and put over. It's not clear whether the defendant is even there. It's not clear whether he's got counsel. Doesn't the Commonwealth, as the prosecutor, have some responsibility there? No, I'm not talking about the promise, just to deal with the case.
Your Honor, there's no question, there's no indication that he was ever deprived of counsel in any way whatsoever. He was represented by counsel throughout these periods, as the record
He
shows.
says he didn't appear in court, and I haven't seen a counter affidavit.
Your Honor, the docket suggests that a bit was issued in the normal course. That would support the inference that he's brought into court.
Mr. Thompson, do we know-
If the hearing wasn't held, excuse me, Your Honor.
Do we know who the prosecutor was?
I know who the prosecutor was at the initial attempted plea. That was
And then in your office, does the prosecutor keep the case?
no, Your Honor,
So, again,
not in the district court.
So to get to the gist of Justice Spina's and Justice Botsford's questions, if it's not when does it next get assigned to a prosecutor?
For the most part, my understanding in the practice in district court is that it's whoever's assigned to the court on the day that the hearing is coming up, for the most part.
On the day that the hearing is coming up?
Your Honor, these are scheduled in advance, and so that the prosecutor's assigned to the courts, and they're assigned to the courts for
And
periods of months at a time.
do you know who the prosecutor was on the date where there's a dispute as to whether or not he was in court?
No, Your Honor.
So is the practice, as it is in most district attorney's office, that in the district court, the prosecutors essentially get the cases that morning as they're going into court?
Or shortly before the hearing, Your Honor. I don't know if
Right.
it's necessarily
They
that
get
day,
them that
but shortly
day,
before the hearing.
Right, so they don't know what they're doing, and it isn't given to one person.
No, it's a practical matter that's essentially impossible for most courts.
Is it somewhat the problem of the court? If the defendant weren't brought in, which is not at all clear to me from the docket sheet, I know that the defendant says that he wasn't, but if the defendant is not brought in and the case seems to be languishing, is it not somewhat the obligation of the court to move the case along?
You know, all these issues are essentially speedy trials issues, which is not essentially the case that's before the court whatsoever.
But it's a public issue. It's an issue of management of cases, and doesn't it fall in part on the prosecutor and part on the court? I mean, what's going on?
Part of the prosecutor, and part of the court, and part of the defense, Your Honor. There's no issue here, no question here that there's ever been any sort of objection to any kind of delay by the defense. That's essentially just as in speedy trial analysis. It's a responsibility of everybody involved. I'm not suggesting that delays are a good thing.
What did the DA's office do to discharge its responsibility?
Your Honor, what it did here, the responsibility here, it didn't have responsibility in terms of this plea issue, Your Honor.
So you can ask for bail and have somebody held on bail, and the case can just sit, so long as nobody asks for something to have happen in the case.
Your Honor, that's not the case that's before the court. I mean, it's essentially, it's simply not the case that's before the court. That really is an issue that's entirely aside from whether or not there has been any kind of promise that was reasonably relied upon.
Mr. Thompson, can I get to the promise thing?
Yes, Your
For a moment, if I may. On page 47 and 48 of your appendix, this is pages 18 and 19 of the plea hearing. On page 47, the defendant is proposing to the judge or defense counsel that the defendant withdraw his plea, have him released, have him held on the detainer, have him sentenced on the detainer, and then essentially come back to plead. The judge turns and asks the Commonwealth for the Commonwealth's position. All we have is, Your Honor, I'm not. And then the judge asks, if he withdraws his plea, do we have any sense of what that inaudible is? Is that like, that's fine with me, Your Honor, no matter? Or do we have any sense of whether the Commonwealth made some additional commitment in agreement with this way to proceed?
No, Your Honor, we don't, and I'm not aware that I don't see that as even, I mean, I'm not sure what it says, Your Honor, and I'm not sure what was the intent of that. Clearly, the record does not reflect any kind of promise that was made by the Commonwealth, and it would be entirely speculative on this to say that there was any kind of commitment on the Commonwealth's part to keep this open-ended, unrestricted agreement made. You understand the context in this case, Your Honor.
Let me ask you this. If, in fact, he had been brought back in on whatever date it was, a date in August, is it your position that the Commonwealth could have at that point simply indicted him or withdrawn the recommendation, saying we decided to pull it off the table?
Your Honor, the recommendation, it's been called a recommendation here. What was going on in that day in court was that the defendant was saying he was going to plead guilty to all the outstanding charges, and the Commonwealth had made absolutely no agreement as to sentencing recommendations whatsoever. In fact, he was suggesting he was going to go for the maximum possible sentence in district court on every charge. There was nothing from the Commonwealth inducing a plea at that thing. The only thing the Commonwealth hadn't done, the Commonwealth has no right to object to the courts taking a plea on that status. The only thing the Commonwealth could have done was either, as outlined in front of the Superior Court, was dismiss the case or have earlier preempted the possibility of a plea by indicting.
Well, let me try to piece that apart a little bit. So let's assume we come in on August, he pleads guilty, Commonwealth represents the max, and then the Commonwealth just proceeds to indict him as a habitual offender.
Well, we can't. Obviously, we can't. That would be a double jeopardy power.
It would?
Yes, Your Honor.
Okay. But the Commonwealth could have simply proceeded any time after July 28th to indict, because there was no promise not to indict.
Yes, that's my position entirely. Okay. The next day, the Commonwealth could have indicted entirely. What I'm suggesting is the mere fact that the Commonwealth did not preempt the possibility of the plea by either dismissing the case or indicting him in advance cannot be taken as a promise that it will not indict in the future. Silence just simply does not equal a promise, Your Honor.
Let me ask you this as to prosecutorial conduct. Let's assume a situation in which you proceed in the district court. Your person says, I'm prepared to plead guilty. You say, I'm going to ask the maximum. Defense counsel says, I'm looking for 10 months concurrent. You go to the plea hearing. Person pleads. Get to the sentencing issue. Defense counsel asks for time concurrent. Judge says, I can't give you concurrent time because you haven't been sentenced to this other matter. You have to go plead guilty in that case, get sentenced, then you'll have to come back. Defense counsel remains silent, as far as we know. Time passes. Doesn't the prosecution owe any obligation to defense counsel to say, listen, if you don't plead guilty by this time, I'm going to proceed to indict, and it's going to be a mandatory 20 years with regard to that. I mean, 2.5 years was sufficient back in July, and now you're seeking 20. Isn't there any obligation of a prosecutor out of fairness to call defense counsel up and say, listen, if you don't do it by this date, I'm going to go ahead and indict the guy?
In fact, there's not, Your Honor, and the case law is clear on that, that statements by a prosecutor of a generalized statement of this is my present intent does not commit the prosecutor to that intent for future references. And I'd cite cases that say that fairly clearly is Commonwealth versus Span, that's 383 Mass. This court at page 142, and particularly 144, and appeals court decision in Commonwealth versus Zanino, which is 17 Mass. App Court 73 at page 82. In that case, the prosecutor in the Span case had expressed an intent to have a probable cause hearing prior to any kind of question of indictment, and then he changed his mind and went ahead with the direct indictment. The defendant was claiming that he had agreed to a continuance of relying on that promise of a probable cause hearing. The court found that there was no reasonable reliance on any kind of promise there because there was no more than an expression of present intent.
But here we know that the ADA was prepared to have him sentenced in district court.
On that day, Your Honor. There's no promise that he was committing to that at any time in the future.
Mr. Thompson, let me ask you this. Going back to page 48, the piece that Justice Cordy pointed to, the judge is clearly asking the Commonwealth to comment on this proposal, which is set forth at the bottom of page 47. Withdraw the plea, have him released on bail, the thing that Justice Cordy suggested. The judge turns to the Commonwealth and says, Your Honor, I'm not, and we don't know whether he said, I'm not in a position to agree to that, or I'm not going to object to that, we don't know. However, the judge then proceeds to do what, at least to have the discussion, to implement what the defendant has asked for. Can we not reasonably infer that the Commonwealth was not objecting to this?
And I'd say, even if the Commonwealth said, I'm not objecting, that again does not amount to a promise that it won't change his mind, that there's any kind of commitment on part of the prosecution that it is binding the Commonwealth or has any intent to bind the Commonwealth.
Your position, I take it, is that the Commonwealth had never made a promise in this case, and it could have indicted the defendant at any time.
At any time, Your Honor. At any time. And even at best, if you take somehow the discussion between the judge and the defendant, if that somehow is binding on the Commonwealth, even though the Commonwealth was not a party to that discussion, but if that was somehow binding on the Commonwealth, the judge made it clear that that was going to be open for 30 days and no more. And yet 6 months passed, Your Honor. There's no reasonable basis for the defendant or anybody else to take that 30-day promise to be extended into the indefinite
I have
future.
a question about the docket sheet, Mr. Thompson. One line on the docket sheet on December 20th says present bail, mid, and every other time it just says mid-issued, but that one time it says present bail. And why would there be a notation about bail if the defendant weren't there? Because obviously the bail would be continued. That seems to me to suggest that the defendant was there at least on that day.
Well, Your Honor,
I mean, you wouldn't write present bail continued, because it would obviously be continued unless there was some issue about bail that day.
I agree with Your Honor. Perhaps he's moving for a reduction of bail. I'm not sure. We don't have the transcript of that. I would also suggest that the fact that the mid-issue suggests that he was indeed brought to the courthouse, whether he was brought to the court into the court itself. the defendant says he wasn't brought before the court, that could happen if there was a continuance and it just never really got before the judge on that
What is the
particular day.
practice in district court if a defendant is haved in, is brought in, but his counsel isn't there? Will they bring him into court even if his attorney is not there?
I don't
Or they
believe
just
so,
leave
Your
him to
Honor.
die?
I know that that doesn't happen as a matter of course in the Superior Court. If, or if for some reason it's delayed, they won't necessarily bring the defendant into the courtroom.
Well, how does the
So you're
defendant
in the
know when his
building.
next court appearance date is?
Then he gets informed, or counsel goes, talks to him, or
Counsel's not
something.
there?
The mid-issues, well, the
Excuse me,
mid-issues,
Your Honor?
the mid-issues for the next date.
Yeah. Okay.
Mr. Thompson, one more question, just excuse my ignorance. Is it the maximum sentence that a district court can impose 2.5 years, or could it impose 2.5 plus 2.5 plus whatever?
2.5 on each count, Your Honor.
But
And they could be consecutive.
They could be
district
considered.
court could impose consecutive sentences?
Yes, Your Honor.
That was not the recommendation here.
That's not, you look at the green sheet, Your Honor, there is nothing suggesting
Agreement.
that the recommendation is anything but consecutive. There's no indication in the green sheet, which is the proffer that goes to
Well,
the court.
I'm just looking at the transcript. He says, the prosecutor says, I'm recommending the max, I'm looking at page 42 of the appendix, the maximum time, okay, so that could be the max for each and every one of the charges consecutive. On the next, on page 44, he says, I would suggest that 2.5 years in this particular case is fairly lenient.
That suggests no consecutive.
So I'm just wondering, was it a consecutive or concurrent recommendation, or what? If you know, maybe it's just unclear. And you're right, the green sheet just has 2.5, 2.5, 2.5, 2.5.
But it says 2.5 years served together on
Where
page
is the green
44.
sheet?
44, Your Honor.
Green sheet is page 28
Page
of the appendix.
44 speaks for itself. It does suggest that that's what he is suggesting at that point, that a total of 2.5 is there. It's not, and there's no indication that that was part of any kind of agreement. Again, I mean, that's what he
Okay.
was saying during that hearing, Your Honor.
All right.
There's nothing else, Your Honor?
Thank you, Mr. Thompson.